Welcome back to COM 330. We're looking at new tech law, and we are in the middle of discussing internet privacy. We're going to look at a case now called Carpenter versus the United States. It was a case where a man was charged with 4 counts of robbery. The arrest and charge was based on cell phone records. The cell phone records showed that he had been in each place where the 4 burglaries had occurred, in addition to other evidence. Now, at trial, Carpenter said that it was private information, and the phone had been seized without a warrant. The phone had been seized without a warrant. And in the past, that had been done a number of times. The case went to the Supreme Court, and the Supreme Court said you cannot seize a person's phone and the contents without a warrant, without their permission. It is private information, and doing that violates the Constitution's right against illegal search and seizure. It took the Supreme Court to actually say search and seizure applied in the digital world as well as the physical world. And so the search was ruled illegal. The person who was facing 4 felonies got off. But that was an important case, Carpenter versus United States, because it showed the Constitution goes into the digital world as well. Another question sometimes people ask is, can police legally search your phone without a warrant or permission? Well, actually, we just talked about that. I kind of jumped ahead, and I talked about some of the things I was going to talk about after that. But basically, it violates the 4th Amendment against illegal search and seizure, so no, they cannot actually do that. Okay, let's look at now the importance of the Internet. The Supreme Court views the Internet as very important. It is seen as part of the marketplace of ideas, and anytime we're talking about the marketplace of ideas, you know that it becomes a very fundamental free speech argument. So it does treat that very seriously. Now, an example is a 2017 case where in North Carolina that a law was created, and it said that sex offenders could not have websites. And you can see why that would be. Perhaps they're concerned with sex offenders luring underage people in and perhaps using it to commit crime. Now, there was a felon whose name was Packingham who was on the sex offender registry, and he created a Facebook account. He didn't use his real name, but he did create a Facebook account, and because of that, he was arrested. Now, he hadn't done anything illegal other than create the Facebook account at that point. He did have a past. So he was arrested. Now, the Supreme Court said that the law was unconstitutional. They said you could not tell somebody they could not create a website. The court explained that the Internet was one of the greatest platforms for disseminating information. That's the marketplace of ideas again. And they said it was where people go to obtain information now. It's where in Greek times they would go to the agora, the forum. The Internet, they said, is the new place where people get information, the new forum. And so it shows... this law shows strong support for the idea of First Amendment rights with the Internet. Okay, we are going to stop there with the new tech law, and we will have more videos coming up for this week.